Donald Trump is facing charges of election interference in Georgia. It is his fourth indictment since April. Trump is now facing a string of criminal trials that could begin early next year.
I don't have any desire to be first or last. I want to try him and be respectful for our sovereign states. We do want to move this case along, and so we will be asking for a proposed order that occurs a trial date within the next 6 months.
That is Fulton County District Attorney Fani Willis making it clear she will push to put Trump on trial as soon as she can. And he won't be alone. Trump is indicted along with 18 others who prosecutors say were key figures in his attempts to hang on to power after losing the 2020 presidential election to Joe Biden. Now, they include his former White House Chief of Staff, Mark Meadows, and former lawyer, Rudy Giuliani. So now for more on this, I want to bring in Chuck Rosenberg. He's a former U.S. attorney and senior FBI official. Mr. Rosenberg, thank you for making time for us today.
My pleasure. Thank you for having me.
So Donald Trump, as we were discussing, is now facing his fourth indictment, this time stemming from an investigation by the state of Georgia into his attempts to overturn the 2020 election results in that state. Can you perhaps break down for us the charges and what they mean for the former president?
Oh, certainly. So this is a big, sprawling indictment, but in many ways, it focuses on the same sort of conduct that he was recently indicted for in federal court in Washington, D.C. That is, an attempt to interfere in a fair and free election and to thwart the peaceful transfer of power. In the Georgia case, Arthi, the prosecutors have focused on the things that happened in Georgia, the attempts to reverse the vote in Georgia and to substitute a set of fake electors for the true electors. But in many ways, it is similar to the federal indictment in Washington, D.C.
When we look at racketeering, for example, how significant is that in this case against the former U.S. president?
Quite significant. So racketeering, and racketeer is really just sort of a quaint word for a criminal, but the feds, our federal law enforcement authorities got a statute in 1970, RICO, the Racketeer Influence Corrupt Organization Statute, that allowed them to go after essentially mobsters and mob families. And mobsters would commit disparate crimes, different people committing different crimes, loan sharking, bid rigging, bribery, extortion. And you could sweep all of these disparate acts into a single prosecutive bucket, a RICO bucket, if you will, Arthi. Georgia, like many states, modeled its RICO statute on the federal statute. Georgia has its own RICO statute, but Georgia's statute is a little bit broader because they've included more predicate acts that could be swept into that RICO bucket. And in Georgia, that includes forgery, false statements, computer trespassing, the precise types of predicate acts that the district attorney in Georgia has now charged as part of this corrupt RICO enterprise.
So to that end, part of what I learned during my research after learning about the details of this indictment is that in certain cases, racketeering, for example, in Georgia can play a role in flipping people within the group that is sort of facing these accusations. So we know, for example, that there's 18 co-defendants here in addition to the former U.S. president. What do you suspect the strategy then is in this case?
Yeah, great question. So frankly, any charge, state or federal, can have the effect of convincing somebody to cooperate, or as you put it, Arthi, to flip. Here there are 19 defendants. That is a big, cumbersome case. If passed as prologue, in my experience as a federal prosecutor, many of the indicted co-defendants will ultimately plead guilty, and most of those will cooperate or flip. But they don't have to, and it's entirely possible, and a prosecutor would understand this, that if she charges 19 people, all 19 could insist on a trial. And again, that would be rather bulky. But I do expect that that number will be whittled down. The opportunity to plead guilty may not seem like an opportunity that you or I would want, but if you're charged criminally, the opportunity to plead guilty and to mitigate your exposure, to reduce the amount of time, for instance, that you might spend in jail is an incentive. And some number of these 19 co-defendants will very likely take that incentive.
Now, we've seen also that the penalty in this case can be 5 to up to 20 years in prison. This is different from the other indictments as well, as it is a state indictment. And we know that there's 4. There are some federal as well. When it comes to this running congruent to the presidential campaign, the potential to pardon and to even serve as president while being convicted, I'm wondering how this is different from the rest.
Yeah, so that's a really good and somewhat complex set of questions. Let me take some pieces of that, if I may, Arthi. Because it's a state prosecution, a president of the United States doesn't have any authority to dismiss a state case or to pardon a state conviction. If Mr. Trump is if he's convicted in Georgia, only Georgia officials could pardon that conduct. And ironically, Georgia is one of the very few states in the United States where its governor does not have pardon authority. In Georgia, it's delegated to a commission. So Mr. Trump, as president, couldn't dismiss or pardon a state case as he could pardon or dismiss a federal case. There are other strengths and weaknesses comparatively of proceeding in a state or a federal venue, but that's the one that comes to mind, and probably why it makes the Georgia prosecution one of the most treacherous for Mr. Trump.
Well, there's a lot to continue to watch here. We very much appreciate your insights today. Thank you for your time.
Thank you.